Guys, if you haven't heard, Andy Signore of Popcorn Planet is being threatened with a lawsuit. But does he have anything to worry about? Let's find out. So that's right, Andy Signore of Popcorn Planet received, let's call it correspondence for the time being, threatening him with a lawsuit. And to talk a little bit about whether he's got anything to worry about and copyright threats in general, I bring back our good friend, Mr. Alan Robert Shaw. How are you doing today, Al?
I'm doing very well and slightly better than you, judging by your croaky voice.
Well, thank you very much. I'm better than I have been. I'm fighting on, as the hashtag goes. Despite people telling me to man up and fight on, I am fighting on. That's what I do. Is I don't give up. So yeah, Andy Signore's received this correspondence. I've seen the video that went up about it. So I thought I'd bring you on, and we can, because we both do a bit of copyright and trademark law, all of which we're going to talk about in this video. What the difference is, whether you can and can't be sued, and what happens really when you're being threatened with one of these suits, which doesn't actually have any merit, which sort of hints at the conclusion we'll draw to, much like we do in court, right, Al? But so let's talk copyright generally. We've done lots of videos on copyright on our new channel, so make sure you go subscribe there. Art and Media Law by the BlackBeltBarrister and Alan Robert Shaw. Yes, it rhymes. Speaking of copyright and trademarks, I think we should trademark that, Al. It's starting to catch on. Absolutely. So we talk about copyright in general over there. You've got to, the big things with copyright. There's got to be something that really subsists. It's got to be something of meaningful value. There's got to be some work behind it, and it's got to be committed to a permanent form. It can't just be de minimis, something very minimal like a word, a letter, even a name, really, or something that's in common phraseology and common use, which is what comes into play in this video, in this threat against Andy Signore. Any more overviews before we delve into what the complaint is?
Well, that's the thing. I mean, there's a couple of issues here. There's what to do with, vexatious, meritless complaints, because even if there's nothing substantive behind them, they can be a headache. And the other thing is, we'll be obviously looking at this from the American legal point of view, but the American view and the European view, they're very, very similar. So this will apply across the board.
Indeed. Lots of people say, oh, this is US law, or this is European law, this is UK law, English law, whatever. Some principles of law are very, almost identical, in fact. I was going to say very similar, but almost identical in various jurisdictions. And indeed, we've got the rule of law, which is it's a universal concept, if not universally applied, in that, generally speaking, the law is applied in the same way everywhere. And so for copyright in particular, with trademarks and all of these sorts of things passing off, those rules are fairly international. They sort of have to be, because the borders have been blurred, if not destroyed, in recent decades anyway. Well, so without further ado, go say again.
Because of the sort of international commerce aspect and trying to get a uniform thing so that it's safe to release films or release software or games or any sort of intellectual property in different jurisdictions. There are various international conventions and treaties. So while there are little bits of devil in the detail, generally speaking, the fundamentals are the same across the board, just because, we live in an interconnected world.
Absolutely. And how else are you going to enforce those? And there are obviously different intellectual property offices around the world, and you can register your rights and your intellectual property at those offices. But nonetheless, it's applied very broadly internationally. So let's move to this video itself. This is the video that was complained of Andy's. Andy won't mind me using this. No doubt, probably link it, share it, and everything else. And it's only one phrase, and it's at the very outset of this video. Let's play it for you.
Guys, it's about to be 1 whole year since the slap heard around the world. And while
That's it. The slap heard around the world was the phrase. So he says it at the very beginning of the video. And also, I believe, in the description here somewhere. Yeah, there it is. Look, the slap heard around the world is about to, etc., etc. So it's just that phrase there. That's the phrase that was complained of. Now, even before we look at the complaint itself, as a intellectual property lawyer, Al, you, as I, would consider the phrase in isolation by itself, just like defamation, and think, well, what do we think of it? What are your immediate thoughts about that phrase?
Well, it's a play on another phrase, which is the shot heard around the world, which seems to have first been used in relation to the American Civil War, or the Battle of Lexington, but was actually used in a poem in the sort of mid-19th century. And it's been used ever since. I mean, people have used it to talk about sort of the assassination of Archduke Ferdinand, for instance. But also it became, a stock phrase. It gets used in sport. It's been used in baseball for particular sort of, like home runs and things like that. So the something heard around the world is now what we call a stock phrase. And as a general rule, stock phrases can't be copyrighted. But this all goes back to the fundamental principles. You cannot copyright an idea. You can only copyright the expression of that idea. And what that means is putting some work in. I can write my sort of novel about an orphan boy who turns out to be a wizard, of which, there's quite a few stories out there on that basis. I mean, the old, the orphan turns out to be special is one of the oldest tropes in sort of, literature. So I can do that. I can't use the same names or the same themes. So, you have to effectively put some effort into it. Either, they always talk about expression, your skill and talent. I mean, this crops up a lot in copyright when people do transformative works. I'm going to base my idea on something you did. It's, well, have you actually added something to it? But also that's just for copyright generally. You can't just sort of like copyright your everyday conversation, even though, it's your own work, it's your own words, and it's, in a way, it is the expression of your ideas. However, as the copyright law says, effectively that puts just like a check on the public just being able to talk about anything. So when you take a stock phrase like this, first of all, it's existed, and the original phrase, even if it was copyrighted, would be well out of copyright now. And effectively, you're manipulating it. It's not really a parody, but it's based on that phrase. And it's what we call prior art. You generally speaking, you get this a lot in patent law where you've come up with an idea, but people say, well, actually, that's an obvious extension of what other cleverer people have done. So we look at prior art and say, well, actually, you haven't really brought anything to the table. You've just, to quote The Simpsons, you've just taken an existing product and put a clock on it. So with stock phrases, generally speaking, and this is the thing, so, we can say straight away, the slap heard around the world, even if this chap was the first person to say it, that would not attract copyright. But also you'd have to show that, he was the person who came up with that. There can be some exceptions. For instance, if a business has a catchphrase or a slogan, they can't copyright the slogan, but if you were to use it to promote your own business, then we get into what we call like passing off and trademark disputes. Also, you can get into sort of merchandising things. For instance, if I was to produce a T-shirt saying "Go ahead, make my day," showing my age there, that the first film I can think of is like from 45 years ago. But if you were to put "May the Force be with you," you could start getting into, hang on, you're basically mooching off the back of our IP. So something like that could be problematic. But if I want to just do a thing saying, I mean, the classic one, you're going to need a bigger boat, or we're going to need a bigger boat, whichever the actual quote is. I mean, actually, interestingly, that is actually something that arose organically on set, because the production crew were always whinging about the fact that the boat they'd been given was too small, and they always blamed everything then on the fact the boat was too small. And it became apparently it was a stock phrase where even if like lunch was late or somebody got a parking ticket, they would just say, "Oh, you're going to need a bigger boat." Because it was their stock excuse, and actually that got written into the script. So that's how these things arise. But in a situation like this, no. I mean, we can say now there is no sort of copyright in this phrase. And that's not just us saying it. That is the American Copyright Office and indeed all the case law, which I believe you have an example there, Dan.
We're going to come up to, I'm going to bring that up on screen in a minute. So what we're doing is that the distinction between a copyright and a trademark, which as you say, you're not going to be copywriting a phrase as such, but you're going to be, if you're developing and marketing your business on a particular phrase, that becomes a trademark. So if we were to refer to those now, it's not passing off because we're not trying to sell you any of the products that they sell. But if we were to say, it's finger licking good, or I'm loving it, or whatever, you know exactly to whom we are referring.
Well, there was the case.
And that's the whole point of a trademark.
Yeah, there's a pub in Yorkshire called the Tan Hill Inn, which is fantastic, and apparently it's Britain's highest pub. It's a really nice pub. Just check that out for research purposes. Obviously, in anticipation of doing this video years later. But they actually just advertise their Sunday lunch, and they use the phrase "come down for a family feast." And KFC threatened to sue them, and of course that all got in newspapers. This firm bullying them. They came back with, we're more insulted that you put our food on a par with KFC. Bring it on. And obviously, in the end, KFC backed down. But they wouldn't have probably had a leg to stand on anyway, because even though that was a slogan used in relation to food, and yes, it's something they use on their menus, to describe their food. Again, that's probably a generic stock phrase. If you sort of opened a fried chicken place and started saying it's finger licking good, maybe you'd be crossing over. But we see this all the time with the guy in Sainsbury's, which I think is quite funny. And I can't remember. I think he ended up changing it or something. But one supermarket chain got really grumpy about it. The other one thought it was really funny. And in all fairness, it's free advertising, and it's probably not like he's actually stealing any of their work. So, yeah, I mean, the way you use a phrase, even if the phrase isn't in copyright, you do get into things like trademark and passing off. But a situation like this, where somebody's just used the phrase the slap heard around the world, it's completely unactionable. But then we move on to, well, what do you do if you get like a vexatious threat?
Well, this is it. So let's look at the threat itself. So this came in to Andy. And apparently this was posted on one of his videos as well, although Andy's blocked out the name because Andy's a nice guy. Hello, Andy. I posted a comment on your video. Ouch. Chris Rock slaps Will Smith back. Notifying you that I own the copyright to the phrase "the slap heard around the world." I haven't filed a copyright strike on your YouTube yet because I'm giving you a chance to respond. If he did own the copyright, fair enough, I suppose. But just to even pause there and to explain this, I've had my own little copyright issues on my channels before now. Even if this was a copyrighted phrase, then there is still the argument, even if it were copyrighted, even if he did own the rights to it and so on, if it's being referred to in either kind of parody or reporting or public interest or all these kind of things, and it's necessary to refer to it. It's like if I need to refer to McDonald's or whoever and their trademarks in whatever it is I'm doing, either news reporting or education or whatever it might be, there's different reasons that you could refer to their trademarks or copyrighted material. So even if he did own the copyright, there'd be a significant dispute against any claim to YouTube videos on that basis. And the way that works is you have a bit of a to and fro, because YouTube starts. I think YouTube get a lot of flack for the way they handle copyright strikes and things like that. But here in YouTube's defense, and I'm not paid at all or asked at all by YouTube to comment on their legal strategies, but here we go nonetheless. They are sort of squarely caught in the middle. They would have to respond legally to a valid legal claim to take down a video on the basis of copyright infringement, alleged thereof. But they would have to respond to a legal and valid claim to reinstate that material if there was a challenge to the complaint. And so YouTube does both of those things. They will, first of all, take it down. If they believe that there is a valid complaint against it, then they'll reinstate it. And then, this goes back and forth. And ultimately, they put it back on the parties. You want to keep it down, you've got to go to court. So anyone that's thinking of bringing a frivolous copyright complaint against a video, just know that ultimately, if you really want to keep it down, you have to go to court over it. Otherwise, it's going back up. So if you're not prepared to go to court, don't bother. So even if he had, we're only on the second paragraph here, even if he had filed a copyright strike, and he can't file the strike, by the way, he can only file a complaint. YouTube applies the strike if they agree with the complaint, but we digress. My standard fee, this is where it gets interesting. And your input as well on this is going to be interesting, Al, to see whether you agree with mine, because I think this is ridiculous. My standard fee for the use of a line of my writing is $2,000 for worldwide publication per use. You said my line at the opening of the video and posted it on the second paragraph of your video description. That's 2 uses. Even that's arguable because it's within the same video, but nonetheless, that's 2 uses. My fee's $4,000. Might sound unprofessional, but I did chuckle a little bit about that. Immediate thoughts, Al?
Well, yeah, because if you have a legitimate copyright claim, you have 3 potential ways of claiming damages, and you can't have them all. You have to you can plead them in alternatives, but you can only sort of recover under one head. You can sue for the amount of money that the person has made using your IP. You can say, well, you've used my intellectual property, you've made all these millions in profits, actually, that's mine, because you only got this because of my talent and skill.
And if I just pause you there, that depends on proving that those profits were as a result of the use of the copyright. So if that was just incidental or a very tiny portion of it, let's say if it was just an obscure, well, actually in Andy's case, it was a few words at the outset of the video, but the rest of the video, if he made any money off it, it's because people watch his channel. They're going to watch it regardless of whether he said that phrase or not. But
yeah, you only really get this where say for instance, you get this with like bootleg good, somebody selling fake Louis Vuitton handbags. They can sort of well, actually, people are only buying that because they think it's Louis Vuitton. So 100% of the profit, the receipts are ours because it just wouldn't exist otherwise.
There was a case, wasn't there, that said like Gucci or something like that. I forget the exact phrase, but it was something like Gucci or whatever it was.
Well,
and
here's
Gucci said, hello.
Because Gucci is a phrase, and especially a lot of British military use it, to say Gucci just means premium. It's like, oh, that's a nice Gucci, like, armoured car or something. It just means it's the posh one. Now, interesting, one thing you've got to be very careful of if you have a trademark is if it becomes so popular, it becomes generic, you use a trademark. Like, for instance, Kleenex is now a generic term for tissues. Hoover is a generic term. I'm doing the hoovering, even if you're doing it with your Dyson. TARDIS also, that has now slipped into general use to mean sort of anything that's bigger on the, more spacious than it seems on the inside. Tarzan fell out of copyright, fell into general usage even before the copyright expired. So yeah, be very, very careful your product isn't so successful. It'd be very interesting because if you were to say, you could use Gucci just as a superlative for any item, but possibly not something Gucci makes. So, that's a really nice, in your lovely Gucci car. But you probably could say, your Gucci handbag, even if you were just talking about another, a posh handbag generically. So this all gets, these sorts of arguments are where lawyers, end up, especially patent and copyright lawyers, this is where they end up getting their yachts. But so you've got that. So you've got you have basically profited on the back of my IP. And you call it an account of profits. You say, I want an account of profits. I want to know what you've made on it. And basically, that money's now mine. The second head of damages, what have I lost because you have done this? So say, for instance, I sell a very expensive product and you're selling bootleg products and people are buying your product instead of mine. I'm not going to go after your profit because you're only selling them for like 10 quid down the market and I'm losing £1,000 a handbag or whatever. However, everybody who buys one of your handbags didn't buy one of mine. So therefore, everyone you sold has cost me $1,000. And obviously, it becomes tricky proving and showing that. But, that is a head of damage people do. And they'll say, you have cost me because people are now buying your thing instead of my thing. And the final head of damage is, what would I have charged you to license my intellectual property.
Yeah, which is broadly what this chap is going after here.
Yeah, you can point and say, look, if you're a photographer, for instance, and you've got you sell stock photographs, you can say, look, I charge £30 for a non-exclusive license.
£30, £50, £150 if you're good or whatever.
Courts will quite often get, if you're in a business like that, they'll say, well, it's up to you to set the market rate. If people don't want to pay your prices, they've got a choice not to use your product. But if they do use your IP, then they have to pay your normal standard rate. However, what usually happens, and what quite often happens, is the courts will impose what they think is a reasonable price. This happens a lot. For example, actually, this is quite useful in this social media age. What do you do if there's a news story and the local news or the newspaper or whatever, they use one of you, they go on Facebook and they see a photograph and go, oh, this is a handy photograph of, that's relevant, I'm going to use it. Well, actually, they have stolen your copyright. Now, the defense they use for not getting in touch with you is this is a fast-moving story. However, you do have a legit copyright claim there. And just to let you know, media outlets know that. And if you just prove and say, this is my photograph, you've trolled it, although it's his Facebook page, it's clearly my photograph, here's the original, with the metadata, they will actually just cough up because they know that they have to pay. And they tend to use the standard NUJ rates. So that's not too bad, actually. If you've got, a photograph of like some local criminal, you can get like 150 quid if they use it. And clearly, if you've got like an absolutely iconic moment, you've got the only shot of the first jet into the World Trade Center or something like that, then obviously, horrible as it sounds, that has a lot more value. And you can charge more for that. But those are the three modes. Now, he's obviously trying my standard charge out rate. But unless he's got a business coming up with, if he's a copywriter in the creative sense rather than the confusing copyright law sense, if he, say, works in advertising or media, and he can say, I will, or even if he's on Fiverr, I will come up with a pithy phrase for you for like $10. And he could point to that, and say, that's my standard rate. It might have a chance. But just plucking a figure out of the air like this, without explaining how you arrived at it. I mean, he does say, my standard fee. But he would have to point to the fact that he's doing this commercially and he's got a business. I mean, the fact is that
straight away.
Yeah, so that's exactly. That's the three ways of claiming damages under copyright. And what you obviously find is people always sue for the one that would bring them the highest return.
Indeed, and he'd have to point to evidence of why he says it's his standard fee, and this immediately, everything you've said, it's a bit like the police caution, isn't it? Everything you've said can be used against you in court. So as soon as he said this, you'll be then looking, well, how do you prove it? Where's your evidence that this is your standard fee, as you put it? And later, if he says, well, it's not my standard fee, it's just what I would have charged then. Think, well, in this correspondence, you said it's your standard fee, and so on and so on. Willing to give you a discount. Please recall that in my letter to you, dated, so it looks like he sent him a letter as well that he sent to his PO box. Now, all this in mind, you can probably read the undertones, or not so undertone, that there is no possible claim here at all. But this leads on fairly nicely, which sort of frustrates me as a lawyer a little bit. As lawyers, we get frustrated sometimes when our clients get harassed with different things. So many times I've had clients come that have been threatened with various copyright and trademark and all these sort of infringements. And they amount to groundless threats, unjustified threats. And depending on where you are, legislation does provide for a remedy of damages if you have received unjustified threats. So that's the next thing to consider. And I just remember there was another thing we were going to refer to, which had the... we even actually, coincidentally, Al, you and I both looked up the same website to look back to this phraseology.
Yep, Stanford University, the home of Andy's favourite professor.
Indeed.
So I thought it was appropriate. I thought you'd appreciate that we're sort of saying, hey, this is a great university, Andy. But yeah, this is all. This is copyright law 101 and short phrases. I mean, what's interesting is though you get a lot of concepts in law that are so obvious to lawyers, and then you say, well, what's the source for that? What's the citation? And you go, because, for instance, the classic one in English law was what they call the golden thread, which is innocent until proven guilty. And that's the case that shows where it says that. And the court said, well, actually, it doesn't say it anywhere. And they came with this phrase going, that is the golden thread that runs through English law, innocent until proven guilty. So we don't need to mention it. It's obvious. But sometimes this happens with copyright stuff where we all know it. I mean, there's a phrase lawyers use a lot, which is, it is trite law, which basically means I can't be looking up any sort of reference.
Yeah, it's so simple. I shouldn't have to tell you where that is.
I always use it's trite law. When I use it's trite law, that means I was sure this was the law, but I can't find any reference to it whatsoever.
Just trust you. It's the lawyer's equivalent of just trust me. Yeah. Don't make me look that up. Just trust me. So no, I thought that I felt like addressing this because it doesn't matter what sort of size you are. It's very often, for me, I find it's with small businesses that are just starting up, just starting out. I had one client who'd come up with a fantastic little business idea, just getting off the ground. And someone once said to me, you know that you're starting to do well when people start complaining. And so this client of mine was obviously starting to do well because someone started complaining. And she'd got this box design into which she was putting the products, which I'm not going to say what they were to not to compromise her identity, but she'd put these products in the box of a certain design, and it was a fairly generic box design that no one could possibly have had any design rights over because it was so generic. And she was receiving these really heavy-handed threats, and then came to us all sort of distraught. And I thought that's a real shame because it's a young business, small business trying to get off the ground. And so we sent a polite but fairly robust response back to say, on your bike, this isn't going anywhere. And if it does, we will vehemently defend it. But Andy's obviously, not small fry in what he does. And it doesn't matter how big or small you are, you get hit with these complaints. I mean, look at Ed Sheeran with his copyright complaints that went to the High Court and took a long time and a lot of money to sort out over, again, a very short phrase. And it's funny that it always turns out to be a short phrase that people are complaining about. So there you go, Andy. Al and I thought we'd put our few cents together, and hopefully that's useful to both Andy and anyone that's watching and anyone that was worried about Andy. Those are our thoughts. Any closing thoughts, Al?
No, that's it. I mean, like you say, the problem with vexatious litigation is in England, because you can apply to, if somebody issues a daft claim, you apply to it struck out. And of course, in England, we have loser pays, winner's cost rule. Whereas in America, normally the rule is you pay your own costs. Having said that, one thing where they can depart from that in America is for vexatious claims. And it's a sanction, it's a punishment. And they say, right, you must pay the defendant's legal fees because you should never have brought this. But yeah, nuisance claims are a problem because sometimes it costs more to defend a claim than to settle up. And it all depends on do you take a pragmatic view there, or do you adopt the $1 million for defence, not a penny for tribute attitude? And sometimes if you have to do that, otherwise, if people know, it's great, every time you just issue a letter before action, they give you $500 to go away. Sometimes it's a good investment to spend the money to say, I am not somebody to be messed with. But in this particular case, I mean, what do you do with the letter? In defamation, we have that standard Arkle versus Pressdram response, which I'll let people look up and Google for themselves because it involves a YouTube unfriendly, rude phrase. But that is something that we do a lot in defamation. Now, I do that. 99% of my potential defamation claims are knocked on the head, after the letter before action, because it's just, go away in more robust terms than that. No, I am not even going to bother doing a substantive response to your letter because it's a waste of time. And that is the response to this is either ignore it or just do a go away, or do you do a substantive response? The trouble with that is then people start nitpicking it and think, because you've accepted there's a controversy, you're usually better.
Well, that's the thing, isn't it? Yeah, as soon as you start arguing about it, then, well, maybe there was something to argue about in the first place. Sometimes it's better left as well. There is nothing to argue about here. Maybe just tell them to go away. And as a final bonus, before we let you all go, if you've stuck with us, well done. Final bonus, because this is for the people that really stick around. Is one thing that we often do for our clients that come to us with small claims. Now, this is obviously pertaining to those in England and Wales, because a small claim is for a claim if it's monetary damages not more than £10,000, and costs, as in your legal costs to pay your lawyer, not the court issue fees and things like that. The fees to pay your lawyer are not normally recoverable if it's a claim for not more than £10,000. That's because the rules for the small claims track applies. There's no such thing as the small claims court. They're heard at the county court, but it's the small claims track. And then there's the fast track and the multi-track, which are more complicated claims. However, there's one little tidbit that's really well worth knowing. If you get a frivolous or vexatious claim against you that is destined for the small claims track and you think it's nonsense, and it's something that we often use, well, I often use anyway. If it's not yet been allocated to a track, then it's not yet on the small claims track. It's just a claim. It hasn't been allocated. Now, when it's allocated by the court, and it's the court that does that, you can apply to have it allocated to a different track, but ultimately the court makes the decision regardless. But before it's allocated to a track, the normal cost rules will still apply. So if you want to get your costs for getting this thing kicked out and make sure you get your lawyer's fees for that, you can apply pretty quickly. Now, obviously, you need to take advice on this, but you can apply quickly either for summary judgment or to strike out the claim before it's allocated to a track and ask for your costs. And I've been fairly successful in that on a number of occasions, and sometimes just frightening them off the pot a little bit to say, this is not yet allocated to a track. We will be seeking costs because it's not yet, you don't yet have the protection of the small claims track. So think again, or we're going for costs as well. And sometimes they just disappear. So that's your bonus for this video. But there we go. Our support as ever for Andy. And I hope that's given you all some reassurance that he's not going to get taken through the mill. So that's all from us. I thank you once again, Al, for your useful input as always. And we make sure you go over and subscribe to our Art and Media Law by the Black Belt Barrister and Alan Robertshaw, linked in the description below.
And already on there, there's lots of useful content on there, but I have lots and lots planned for you. I was scouting locations yesterday for an upcoming video. By scouting locations, I mean going, oh, it's raining, I'm going to go in my favourite pub and spend the rest of the afternoon and evening in there.
Sounds good to me. See you over there. Make sure you subscribe. Thank you for watching.